The next stage then is the investigation. The goal of an investigation is to investigate the allegations of abuse or neglect, evaluate the risks to the child, and recommend the next action for the case. Like I said, the investigative stage is very short. It's normally 30 to 45 days. So the investigator's sole purpose is to evaluate the current risk to the child. Are they safe where they're at? If not, what can I do to make that child safe in the immediate now? And then recommend the next action for the case, which could be to make a community referral and close their case, or it could be to move it on to family-based. In fact, I have a slide for this. I'm getting ahead of myself, so we'll talk about it more in depth in a minute. Here in Bexar County, we actually have some specialized investigative units. We have 2 night units, and they are the ones who work overnight the cases. They also work on the holidays. They're the ones who are going out on the weekends. We have a priority 2 unit. We have a military unit who specifically works with military families that we receive reports on. We have sexual abuse units who also specifically investigate allegations of sexual abuse. The domestic violence unit that I spoke of, housed at the Family Justice Center. The liaisons that we have at the hospitals and juvenile probation are all considered investigators. We also have screeners, and those were positions that were created, about 5 or 6 years ago now, and they screen all the priority 2 cases that come in with school-age children. They kind of make some initial phone calls to determine what the situation is before routing it on to the investigative units. And then we also have special investigators, and all of those investigators have law enforcement, some sort of law enforcement background, and so they handle some of our more severe allegations of abuse and neglect. There's 36 investigative units in total here in Bexar County, and 15 investigative units in the rural counties. Priorities for investigations are based on the assessment of immediacy of the risk and the severity of the possible harm to the child. Priority 1 investigations, our agency responds as quickly as possible, and the investigator is required to make contact with the child within 24 hours of receiving the report. And a priority 2, the investigator is required to make contact within 72 hours. And that actually changed a few years ago. Prior to that, priority 2s, the investigators had 10 days to go out on. So the legislator changed that a couple years ago, and I think that was probably for the better, to keep kids safe, so they go out within 3 days. We do conduct joint investigations with law enforcement at times. Immediately upon receiving a report that alleges that a child has been or may be a victim of a crime that faces immediate risk, physical abuse, sexual abuse that could result in death or serious harm, CPS informs the appropriate law enforcement agency and requests a joint investigation. So that doesn't happen all the time, but it does happen. And our special investigators, like I said, have law enforcement background, and they kind of help navigate through that law enforcement system, and oftentimes go out on these joint investigations. Sometimes we also involve law enforcement during removals if we're needing assistance from the police for removals, so we can utilize law enforcement for that way, or also for welfare checks during an investigation, or even our legal cases. I've done welfare checks myself. And also, just a side note, all of our intakes are moved on to the law enforcement, but not all of them are serious enough to require a joint investigation, but law enforcement does receive notice of all of our intakes. Just to speak briefly about some general investigation steps, the process that an investigative worker goes through once they receive the intake. Children are interviewed and visually examined based on the priority, how quickly they can get out there to see them. Audio tape or videotapes and photos are taken of the children. The allegations are discussed, and a risk assessment is completed with the parent or the alleged perpetrator, or the alleged perpetrator, because sometimes the alleged perpetrator is not the parent and sometimes it is, but it has to be somebody living in the home. We only investigate reports of abuse going on in the home that the child resides in. Criminal history and CPS history is reviewed, preferably before you speak to the alleged perpetrator and the parents. When necessary, records are requested, medical appointments or drug Drug testing may be requested. A home visit is conducted. Other children, the siblings, and the home are interviewed and examined. Collaterals and the reporter are contacted so that we can gather information that way. And if needed, a safety plan is completed. Just as a side note, children can be perpetrators if they are at least 8 years old and are greater than 3 years in age of the victim. Safety plans, I mentioned that the child in an investigation could possibly be placed into a safety plan. And safety plans are actions to be taken by the family to ensure the immediate safety of the child or the children. There are specific tasks that are listed on the safety plan. They're observable and they're achievable. They're voluntary. It's not a legally binding document, and it's temporary. There's a time limit on it. It's short term. Safety plans can be used in the investigation stage as well as in the family-based stage of service. It's oftentimes things like grandma will supervise all visitation between mom and her son for this extended period of time, or mom agrees to participate in counseling services for 6 weeks, or mom agrees to go take a drug test on this day. And it could be all three of those tasks are listed on there. It could be one of those tasks, whatever the department feels is necessary for the child's immediate safety to be guaranteed. So it could be that someone is agreeing to live in the home for a while, or it could be that someone's agreeing to move out of the home for a while, and then it's in writing, and it's there so that everybody can say, this is what we agreed to. But again, it's not legally binding. It does not give custody of the child to somebody else or to the state. So the parent is still the legal guardian in those cases, whether or not the child's been asked to go live somewhere else for a while or remain in the home. By the end of the investigation, the investigator is charged with making two major decisions. The case disposition, which will rule on the allegations that we received, and they can be either found reason to believe, which is validating them for abuse and neglect. The allegations could be ruled out. They could be found unable to determine. All the investigations, the burden of proof, as you can see down there, is a preponderance of evidence. And that's just saying about 51%. If you had a seesaw, there has to be just enough evidence to tip it up this way to be found reason to believe. So if it's unable to determine, then maybe you're just still sitting right here on the fence. You're not sure if the allegations are true or not. Or something, they just weren't able to get that final piece of the puzzle. But something happened here, but we're not sure who was the perpetrator or exactly what occurred. And then lastly, unable to complete is if we're not able to, for whatever reason, complete the investigation. It doesn't happen very often. It could be that the family is continually moving around and we can't get in contact with them. Those cases are flagged in our system, so if we receive a new referral on that family, it's kind of brought to someone's attention immediately that there was an investigation that was unable to complete in our system. And then once they make a decision on the case disposition, they have to decide what the case conclusion is going to be. So that's going to be, are they going to close the case once they've decided if the allegations were ruled out or reason to believe or unable to determine? Are they going to refer a family to community services and then close the case? Are they going to open the case for in-home services, and that would be the family-based safety services? Or are they going to petition the court for emergency custody? So at the end of that investigation, they're going to be making those two decisions, and not alone, with their supervisor and with other people. At the end of an investigation, the reporter will receive a letter notifying them of the conclusion of the investigation. And the letter is stating, just if you receive a letter that's stating that abuse or neglect did not happen, it doesn't mean that the report wasn't considered. It doesn't mean that it wasn't investigated. It just means that the evidence that the investigator was able to gather did not support the burden of proof for confirmation of abuse or neglect. If before an investigation is completed, the investigating agency, which here in Texas is Child Protective Services, believes that the immediate removal of a child from the child's home is necessary to protect the child from further abuse or neglect, The investigating agency can file a petition to take action under Chapter 262 of the Texas Family Code to provide for the temporary care and protection of the child. So under the law, our agency does have the authority to remove a child from their home if we feel that that is necessary during the investigation. These are some things that happen with the removing of the children with an emergency order. A sworn affidavit by a person with personal knowledge and stating facts sufficient to satisfy a person of ordinary prudence and caution that there is we have to show that there's immediate danger to the health and safety of the child, that no time consistent with health and safety of the child, that there is no time available to wait to have a hearing, that we needed an order, we needed to take action immediately, and that's why we received an emergency order. So there wasn't time to wait to all convene in court together, and that reasonable efforts were made to prevent or eliminate the need for the removal of the child. And reasonable efforts could be that there was a family-based case open for 3 months and the situation continued to deteriorate to the point that the child was in immediate danger. So, or that we offered that community referral and, the parents didn't comply. So there could be a lot of things, but the department is required to take reasonable efforts to prevent the need of the removal of a child, if at all possible. I know we've kind of talked a lot about family-based safety services already with your questions, but the goal is to work with the family to reduce risk to the child, prevent unnecessary removal of the child, and achieve permanency and safety of the child. Here in Bexar County, we do have different FBSS units. To answer your question, about the guidelines for the visits, it kind of depends which stage of the family base the family's in. There's regular family base, intensive, moderate, and there's kind of some of the reasons why they would be assigned to the certain units. If a family is in a family-based case versus just an investigation where they received a referral, there's more in-depth assessment of the family functioning, what their strengths are, where they need assistance. Actions are taken by the family to reduce risk to the children. They're given specific tasks, such as attending certain services or getting certain resources in place. It's voluntary. It's not legally binding. Again, however, the department can petition the court for a motion to participate if the family is not complying with services, and we really feel like that's necessary. And at that time, the judge does court order them to participate. If he feels it's necessary, the case has to be proven up. And then there's also reintegration of the children if they were voluntarily placed out of the home. Then the caseworker would work with the family while the children were placed back in the home. Family group conferences is another tool that we use at our agency. It's a chance for families to be involved with their service planning. Family team meetings are offered to the family prior to the removal in non-emergency situations. They're often used during the investigative stage. It's a chance for the family to come together with the department to find a solution to the problem to prevent any kind of removal. Family group decision making is offered to families in ongoing cases. It could be in a family-based case or in a legal case where the children has been removed. Again, it's an opportunity for the family to be involved in the case decision making as far as creating their plan of service, identifying their needs, to have an active role and to bring people to the table that they want to be involved. Everybody signs a confidentiality agreement there at the meeting. It's an opportunity for the department to do some information sharing then with the family, with their relatives, and whatever support system that they would like to have at the table. The conservatorship case, this is the stage when the child has been legally removed from the home. The goal is to work with the family to reduce risk to the child, achieve permanency and safety for the child. We do have some specialized CVS units. The legal unit, like I stated before, is housed at the courthouse. They're the legal liaisons. Legal ongoing units would be conservatorship caseworkers who are working with the families, going to visit with the children who are in substitute care placements, whether that's in a shelter, in a foster home, or placed with a relative. We also have a drug court here in San Antonio, and that's a specialized unit that works with Judge Sakai's court. Drugs are the primary issue. They're kind of more intensive services working with the family, and they have very swift access to treatment here in San Antonio that way. There's PMC units, and that's permanent managing conservatorship. Those units unfortunately have a lot of our older kids who are in permanent state custody and who might not have an adoptive home or a permanent home, and they're kind of here in foster care. We have a placement team, a centralized placement team. They work to find placement for children who've been removed from their home. We have adoption units, and they work to recruit families for children who need to be adopted. And Project Push and Project Swift are unique here in Bexar County, and Project Push works with relatives to push the adoptions through. That's where they got their name. And Project Swift works with children who are being adopted by their foster families. And here in Bexar County, we hold a monthly adoption ceremony that's unique here in this county, and we also lead the nation in the number of adoptions that we do every year. Here's a quick overview of the legal process. After a child is removed, whether it's an emergency or non-emergency order, regardless, before 14 days is up, we have an adversarial hearing, and that's the hearing where the state has a burden of proof to show that the children do need to remain in state custody. The judge then grants that order. We have a 60-day status hearing, a permanency review hearing at 6 months, another permanency review hearing at 10 months, and at this time, an extension could be granted to the family if they're engaging in their services, if we would like to continue working with them, or if their attorney files for an extension. Otherwise, at the 10-month mark, the first merits hearing is set. And if an extension is granted, then a new date is given. And a merits hearing, that's our final trial. That would be where the department would be seeking termination of the parental rights. And after termination is granted, or after the merits hearing, there's a placement review at 14 months, and then every 6 months thereafter that the child remains in foster care or in the state's custody. And all of those hearings are opportunities for the judge to hear what's going on with the cases, to monitor the progress, to ensure the department's doing their job. We also have here in Bexar County what's called an ATP hearing, and that's an authorization to place, and the department has to have one of those anytime we want to place children with relatives. And that is after a home study's been completed, we'll have to go to the court, and the judge will have to grant the placement. Those are not usually contested, although they can be. And then the adoption hearing is when adoptions are consummated. And like I said, we have a monthly mass adoption here, but that's not the only time adoptions happen. There can be private adoption hearings as well. The Adoptions and Safe Families Act of 1997 really started promoting the permanency for our kids, and they saw that it was a real problem that children were lingering in foster care. And so it also requires us to complete our conservatorship cases, to legally resolve them, I should say, within a maximum of 18 months. It requires a year, but it allows for a 6-month extension if needed. And that's really to promote the permanency of these kids, because foster care is not a place to grow up. The state has not been known to be a very good parent. And so we want all of our kids to have forever homes, whatever that might look like for them. But the Adoptions and Safe Family Act, the result, she says the result down there, dual tracking. Basically, it requires us to start permanency planning from the second they enter into foster care, and we do that at our staffings, and we do that at our court hearings. We're required to say what the plan is for the child, what that permanency plan is, and sometimes can be dual tracking. We always have a plan B. If we can't have reunification, child's placed with grandma, and grandma would love to adopt this baby. And so we always have a plan A and a plan B, and we're required by federal law to have that. Termination of parental rights, our burden of proof at court for that is clear and convincing evidence. We only have to have a preponderance of evidence to validate an investigation and to possibly seek a removal of a child. But to actually terminate parental rights, we have to have clear and convincing evidence. And the state has the burden of proof at those trials. Just The next step up is beyond a reasonable doubt, and that is for criminal hearings. So we're a little bit below that to terminate parental rights. We have to have grounds to terminate. They're all listed out in the family code, so we have to prove that one of those things happened, and then we also have to prove that it's in the best interest of the child to terminate the parental rights. So we have to meet that two-pronged test in order to have parental rights terminated, or I should say the state does, the department. And hopefully this will answer your question. Permanency for children can look like a bunch of different options. We have reunification could be one. After they enter into the state system, we might be able to reunify with their parents. It could be adoption by a relative, adoption by non-relative, and usually that would be a foster parent. Permanent managing conservatorship without termination of parental rights can be given to a relative, or it could be given to the state, which obviously permanent managing conservatorship without parental rights being terminated is not an ideal situation for the child to have PMC to the state, because that means that they're not legally free for adoption, but they can't go home maybe with mom and dad. However, if that does happen, the department does have an obligation to continue working with the parents, offering services to them to try and rectify the problem so that maybe reunification could be possible. We also can resolve a legal case by giving permanent managing conservatorship to a relative, but without terminating the parental rights, and the parent would maintain possessory rights to that child. So they might be able to have visitation, they would be legally able to get information about them, but they wouldn't be the primary custodian of that child, and they would not be the person making all of the decisions for that. They would not be the primary decision maker for that child. They would have a legal guardian who is not the parent. And so that could be a situation that this parent that you're talking about is in, that permanent managing conservatorship was given to a relative and her parental rights were not terminated. But, what? Yeah, that has no time. The parent could theoretically hire an attorney and go to court to ask that order be modified. But if parental rights are terminated, then that's it. Their legal ties are severed to that child. But there is that other option and another resolution that their rights might not be terminated, but the legal guardian becomes somebody else. And there's no time limit, but their CPS case is then closed. If PMC is given to another relative, their case is closed with the department. If it's given to the state, their case is not closed. Just a few statistics here in Bexar County. We do approximately 18,000 investigations each year. There's approximately 1,200 new family-based cases open at any given time, with 175 to 250 referred per month. There's approximately 1,200 new children in foster care each year, with about 3,500 in care at any given time. And we have over 500 kiddos waiting for adoption who are legally free, which means that their parents' rights have been terminated and they are available for adoption right now.